Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trusts and a leading estate planning attorney serving Orange County families for over 25 years. I'm Lisa Mosby, your host, and today we're talking about the sandwich generation crisis, estate planning when caring for aging parents and children simultaneously. Welcome, Brian.
Hi, thank you for having me on today.
In Orange County, the cost of living is at an all-time high. How can the sandwich generation parents protect their own retirement savings while simultaneously funding their children's college and their parents' assisted living arrangements?
That, obviously some of it's estate planning, some of it's financial planning. On our side as estate planning attorneys, our job is to make sure that, if something does happen where somebody can't do things for themselves, whether it be our parents and obviously our children, we want to make sure there's documents in place to make sure we're able, or somebody else, God forbid we're not able, can take over. Because if you don't have the right documents in place, it can get very expensive as far as at that point you're starting to hire attorneys, getting conservatorships and such, and which is, the ability to make decisions for somebody if there's when there's lack of documentation. We definitely want to avoid that situation. Because again, it's very expensive. As soon as somebody has to go to court, you're paying tens of, potentially thousands or tens of thousands of dollars to deal with that court issue.
For OC families with parents who own high value real estate, how do you qualify them for Medi-Cal, for long-term care in 2026 without the state coming after the family home through an estate recovery claim?
So, there's two issues when we talk about, in California, we have Medi-Cal. Obviously, other states, they may be called Medicaid. And Medi-Cal can pay when you don't have a lot of income, especially, can pay for things as simple as your supplemental part of your Medicare. It's called Medi-Medi, the Part B. Or it can be covering assisted living. It might be covering in-home care, or obviously, unfortunately, nursing homes. And so those are big benefits, especially when a nursing home in Orange Counties, on average costs about $10,000 to $12,000 a month. That's a massive expense. And, if you don't have a lot, especially liquid assets, the government can come in and cover cover the costs for a nursing home. But the issue is that if when that person who used Medi-Cal passes away, the state can place what's called a Medi-Cal estate recovery lien on whatever assets they have. Try to recover what they spent on Medi-Cal on that behalf of behalf of your parent there. And so the issue is, how do we avoid that lien? Now, fortunately, California, we are one of the more liberal states in the sense of they do make it fairly easy now. Recent law changes over the last 10 years have basically changed it so that it's fairly simple. If that person who passes away is able to avoid probate for their assets, there's no lien. It's pretty simple because probate is where what happens in probate is part of the process is whoever's in charge. If they're in probate, the executor is part of the process. Will have to go to court. They'll have to go to Medi-Cal and say, did you spend any money on behalf of this person? If they did, Medi-Cal will present a bill. Okay, and so that's the estate recovery lien. And in order to get out of probate, which is where all the money is tied up in, that money, they'll be just like any other creditor. They'll have to be paid first before anybody else gets any money. And, obviously if they're spending $10,000 or $12,000 a month, or, especially when that person's been, disabled for a long period of time or anything like that, that's most people, that's going to wipe out whatever inheritance there is. But fortunately, they made it very simple here in California is avoid probate by having something like, if you own a home, you have a revocable living trust. You fund that trust. Again, most importantly, you fund the trust. You fund the trust with the house, with the deed that puts the house in the trust, and all the other assets are either in the trust or either the trust or somebody else's name as a beneficiary on your financial accounts. That'll avoid probate. Okay, and if you avoid probate, there's no lien, and it's very simple. And it's a revocable trust will work just fine. In other states, you actually need an irrevocable trust, but here in California, a revocable trust works just fine to avoid Medi-Cal estate recovery lien.
And many OC families are moving parents into their own homes. What legal caregiver agreements should be in place to ensure that the money spent on home modifications or care is documented and doesn't trigger negative tax or inheritance issues?
I mean, I think for the most part, there's a couple issues there. A, you want to make sure, regardless of whether the parents are moving in with you, do you have the legal authority to make decisions for them if they cannot? That's a number one issue. Do you have access to their medical information? And then it becomes an issue of fairness in terms of the family, in terms of if you are one of siblings and you're taking on either the financial responsibility and or the care responsibilities, are you being fairly compensated or just reimbursed for the expenses you're incurring for taking care of your parents? And that's something that needs to be addressed in the parents' estate planning. Or, as I tell people, the other is, if you come to some sort of legal agreement with the parents as, a contract essentially, whether they're paying rent or rent is being forgiven or being paid for you taking care of them, at least then, that's something that can be submitted, presented as just like any other bill at the time of their passing, where, you can be recompensed from the estate at that point. Because otherwise, like I said, it can, especially if you have multiple siblings and one of them's bearing the burden, that can be somewhat unfair. Now, at the end of the day, obviously not everybody needs to be recompensed for those things. And, obviously if you're only child, then, well, you don't have to worry about that as much. But the issue is, fairness, and how do you address that issue without causing any, obviously the last thing you want is at the end, one of the child who did take care of them is saying, I was promised this and I was supposed to get that. And there is no legal document expressing that. Now we have potential, for causing a rift. And again, that's our goal here, is to do whatever we can to make sure we avoid those potential rifts by addressing these issues up front.
What happens if a sandwich generation parent becomes incapacitated themselves? Does the current estate plan have enough depth to allow a spouse or a guardian to manage the affairs of both the minor children and the aging grandparents simultaneously? How do you plan for that?
You know, some of it's legal. Obviously, you having an estate plan for yourself, obviously that addresses if you're incapacitated, who can make financial decisions and or make medical decisions for you. Also, there might even need to be, short-term documents in terms of who would make those decisions for your minor children. As far as, your parents, that's more their planning to make sure that there's a backup to you in their planning that says if you can't do those things for them, that they're, that's plan A, but there's plans B and C. And that's what most, good estate plans will have. They'll have both addressed, what will happen as expected, who should be in charge. But if something happens and that person's incapacitated or God forbid passes on, then what? Then who's in charge? And again, because the whole issue with doing this is we want to make sure that we avoid, have people having to get conservatorships because of the cost and time associated with that. And that's just by making sure you have, fairly simple documents in place that appoint the people you trust in some order to take over when you can't do things for yourself.
So, Brian, if a parent passes away while living in a home owned by the adult children or vice versa, how has Proposition 19 changed the way we handle property tax assessments for these families?
So, the biggest issue with Prop 19. So in California, we have what's called Prop 13. Prop 13 says your property taxes do not go up more than 2% in any particular year. And as a result, we, especially our parents or even ourselves, we are living in a house, especially if we've lived in there for a while, that has artificially low property taxes. And so the issue with Prop 19 is, it used to be fairly, as example, if you have a primary residence and you pass it on to your kids, they will be able to avoid any reassessment to the higher values if it was your primary residence. And same thing with other property, rental properties even, that they could preserve some of the, prevent some of the reassessment and get some exemption for that. Prop 19, which was enacted about 3-4 years ago, took away most of those exemptions or the exemption from reassessment. And so now the properties are under, except a very limited circumstance, are going to be reassessed at your passing. And the key here is the only exemption that exists now is, or the primary exemption that exists now is if that home was the primary residence of the parent, and it goes to a child, or vice versa, it could go the other way around in theory, goes to a child and that child moves into that property, then that property, for as long as the child lives in the property, will be exempt from reassessment, or yeah, will be exempt from reassessment. And that's a big deal, obviously, because, we have a lot of people that are paying a few $1,000s in property taxes when they should be paying tens of thousands of dollars in property taxes if the property is reassessed. And that's every year. And so that's a massive difference. And so, people aren't planning for that, how that's going to work. Especially, again, if they're going to sell the property, it's not a big deal. But if they're going to keep the property, how do you plan for that and make sure things are set up correctly, so that when the property does pass from the parent to the child, that, they can qualify for the exemption. And or if you're going to make the mistake of transfer the property present day, what are the tax implications of doing so?
And Brian, with us living in the digital world that we do today, from a senior's retirement portal to a teenager's social media, how do you ensure a caregiver has the legal keys to manage the digital footprints of everyone in the household?
That is the big change now. It used to be, if something happened to you, we could rely on the mail, that over the next 30 days to get a bunch of statements, and you would know what you need to know about that person. But now everything's digital, tied to their email. And, especially depending on the assets, especially if we're dealing with things like cryptocurrency, other digital assets, there aren't a lot of great ways to access or get the value from those assets unless you have actual access. And so then the question is, how do you convey access to somebody in a secure fashion? I personally use a password manager, an online password manager that's, presumably secure. And then I share those, create a family vault, electronic vault, essentially, and have a mechanism, in case of emergency, break glass, paper that they can access. Maybe we keep that in a safe or something like that, that would give them access to all that information. And that accomplishes a number of things. A, it inventories things for them, whether it be where all the money's at, or digital assets, where the digital assets are, and or it also, what are the bills? What are the credit cards? What are the login for the waste management, or the power company, whatever it is. You want to make sure that you can securely pass those passwords on to somebody without write on a piece of paper and hoping there's not a fire or something like that. Or you put it in a safe deposit box, and they actually get into the safe deposit box. And on top of the fact, when you put it on paper, the odds that that paper is up to date, because often you should be changing your passwords. You want some digital format that will either pick that change up automatically. But the key is that whatever it is, your the username, passwords, and such is up to date, because obviously it doesn't do any good to have it have a list if it's not being kept up to date. And so, or even just the digitally, it's we should be using these passwords that are not simple. And I can't memorize a 16-digit password, but my password manager can memorize it. And so that's just a just much more secure way to manage the assets. And then again, with the electronic, like a family electronic vault, how we can make sure whoever's going to take over after us can easily gain access to all the username, passwords, and things like that they might need to deal with our digital footprint.
In 2026, we have better diagnostic tools for cognitive decline. Should our power of attorney documents have immediate powers or springing powers to ensure care isn't delayed for a parent with early onset Alzheimer's?
I mean, there's two documents that deal with incapacity. There's the power of attorney, and then there's a healthcare directive. And we treat them a little bit different, because usually in the healthcare directive, as an example, we typically recommend that the power be immediate. Okay, so that people can, there's, even if somebody is incapacitated, there's no bureaucracy involved. Okay, if they can't make decisions, the next person that's on the list can start making decisions immediately without issue. So, and that's also because there's, some people don't want that person to have authority if they can make decisions. And in the case of healthcare, the doctor's not going to ask anybody else if you can make decisions. They don't care what your healthcare directive says. This person can make decisions for you. If you can make decisions, they'll ask you. So I'm not concerned about immediate, versus in a power of attorney, it's a little different, because power of attorney is very powerful in terms of giving them access to the money, as an example. And again, some people just may not be, they trust and love their children, but maybe just not quite ready to give them control. And that's why it's what's called springing. It's if they're declared incapacitated, there's a doctor's letter saying they can no longer handle their financial and legal affairs. That person can take over and now access bank accounts, pay bills, or do whatever. Now, with that being said, there is a gray area there. The gray area is, unfortunately, as we age, where you are, maybe you've been diagnosed with dementia or undiagnosed for that matter, but you're still, relatively capable, but maybe are now a little more vulnerable. And we're seeing now, especially, I've seen it with family members where you're much more skeptical, much more susceptible rather to being scammed. And so you have the legal authority to go take money out of your bank, okay, because you're not completely incapacitated, but maybe your judgment's a little diminished, and that's where that's where having immediate power of attorneys are important, because it's not based on incapacity. That person can help you now. They can help monitor things in addition to yourself, so you're not taking power away from yourself necessarily, but at least they can help monitor. They can be told things. They can ask. They can monitor your bank accounts easier. And so that's why it's important in those cases to have make the power attorney immediate, not based on capacity. For some of our clients, we'll set it up so that the power of attorney will be springing, but we give them a blank document that they can sign anytime that will convert the power of attorney to immediate. And that way it's flexible. You don't have to go back to your attorney to get that done. You just sign this piece of paper that we have ready to go if you think you need help. And that's what we tell them. If you get to the point where you think you need help, sign this, and that will give your, whoever your power of attorney is, the immediate ability to start helping you.
Brian, thank you so much for today. You've cleaned up some phrases, some forms that I had never heard of. So I hope our audience had as many takeaways from today as I did. Folks, your estate plan is only as strong as the people you trust to carry it out. If you're not sure who to name, or you just want to make sure your choices are still a good fit, Brian and his team can walk you through your options and help you make the right call. Visit ocwillsandtrusts.com to learn more or schedule time to discuss your specific situation. Also, be sure to like, subscribe, and give us a review if you enjoyed today's episode. Thank you so much.
Thank you so much for having me on.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.